Welcome to Canadian Justice. I'm Christine Van Geyn, and today we're discussing a new proposed law that's been introduced by the federal Mark Carney government, Bill C-8, an act respecting cybersecurity. This is a reboot of a Trudeau-era bill, C-26, and it has some civil liberties experts concerned that it could lead to violations of privacy rights and lead to increased state surveillance. The bill has two main components. First, amendments to the Telecommunications Act that give the federal government broader powers over telecom service providers, including the power to order a service provider to stop using or remove a product or service. And second, it creates new obligations on what the act refers to as critical service systems providers, and this includes sectors like banking, telecom, energy, and transportation. The bill would also give regulators enhanced powers to verify compliance, along with the power to impose very high penalties for some offenses up to $15 million per day. The scope of the new bill has experts concerned, and here today to discuss some of those concerns are Matt Hatfield from OpenMedia and Tamir Israel from the Canadian Civil Liberties Association. Thank you both so much for joining me today. Matt, I'll start with you. I think there are a lot of specifics we can get into about what the government might be able to hypothetically do with some of these new powers, but I think at its core, the biggest concern around C-8 is that it gives very broad and discretionary power to cabinet, to certain cabinet ministers in particular. What do you want us to know about why that should make people worry?
Yeah, so this is a bit of a concerning trend we've seen with a lot of legislation in recent years, and it's setting up legislation as sort of empty shells where a broad set of powers is awarded to government, and then we're told that protections and safeguards and necessary guidance will be provided in regulation rather than in the law. I think from the perspective of government, this is desirable because they think it'll give them more flexibility, they can adjust as they go along. But of course, from a protection of our rights and liberties perspective, that's a very concerning situation. It means that you don't have actual protections. You have sort of discretionary ones that the government chooses to award you in regulation and can withdraw in the future. And so on this bill and many others, we're looking for more safeguards and protections built into the law.
So one of the components of this bill, Tamir, is the power to order a service provider to stop using or remove a product or service. And I think when people hear language like that, they just don't know what it means and how it might affect their life. So maybe you could give us an example of what that might actually look like in practice.
Yeah, so there is actually a very concrete use case envisioned for this part of the bill, and it was actually brought into effect. I mean, we could really call it the Huawei provision because it was brought into effect to order telecommunication companies in Canada to remove equipment by a particular vendor, Huawei, a Chinese-based company, from their networks. And again, in practice, what this would look like is that maybe a little bit gradually, companies would replace any equipment that they have from this particular vendor, which is mostly going to be mobile cellular signals, so like 4G and 5G equipment from their networks, and replace it with something else. It sounds pretty basic, and this part of the bill is not necessarily the most controversial, but even here, there are some issues with it. For example, the cost of this, we have competition issues in Canada in the telecommunications sector, and the cost of this might not be borne evenly by different service providers. And then there's also Huawei is kind of the primary use case envisioned by this part of the bill when it's being brought into effect. But there's also a risk, with this framework that, and I should just say that the concern with Huawei very basically is there's a lot of overlapping rationales, but the main concern is that because it's a Chinese-based company, the Chinese government can secretly order Huawei to make its networks more amenable to foreign spying on people in Canada. Now, whether that's the theoretical kind of argument for removing this. And there is a bit, of course, of irony here because the government's solution to this concern is that, we have a bill that will, as we'll hear, allows it to issue its own secret orders that could also introduce backdoors. But even with this framework here, where there could be a legitimate objective, what you want more than really briefly, more than a high level, like a high level ability to make these orders is a rigorous framework where the vendor being impacted gets notice that their product is being banned and has a chance to kind of address the
Right.
underlying rationales for it. Yeah.
We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing Bill C-8, which is a federal piece of cybersecurity legislation that has some civil liberties experts concerned. Now, in the last segment, Tamir, you had mentioned that this bill could have the potential to allow the government to compel telecoms to build what are called backdoors. These are technical access points for security agencies and law enforcement. Matt, maybe you could explain a little bit more about what a backdoor is, how it's used, and how this legislation might allow for the creation of them.
Yeah, so something that law enforcement all around the world has said that they want and should have for a very long time is the idea of a path into private messages for only the good guys. We'll only use this in emergency situations. It'll only be for, vetted law enforcement. And the issue with that idea is that it's simply not technically possible to have a backdoor that is only available in those circumstances for good guys. Both it can be misused by law enforcement for much broader purposes, but also once that path is technically created, a lot of other entities can find out about the backdoor and make use of it. We're talking about foreign states who could access our private messages. We're talking about hackers, vengeful exes, all kinds of people could theoretically get in there. And in some cases, law enforcement will try to say, oh no, we're going to respect encryption. Your encrypted messages won't be intercepted. It's that we'll do what's called a man-in-the-middle attack. So rather than actually breaking encrypted messages at some early stage of your message going through the system, it'll be intercepted before it's encrypted, and we'll only have access to that part. If that sounds like it's functionally the same to people, it is functionally the same, but they will argue for it. Sorry, go ahead.
I just wanted to ask about another portion of this bill that has attracted, I think, perhaps the most attention. There are some that suggest that a portion of this bill could allow for the government to order a telecom service provider to actually cut someone off from their phone or internet. Is that, Tamir, is that your read of the bill? And are there any guardrails in place to prevent that from being abused? I mean, I can see many reasons why a government might want to prevent one of their political opponents from having access to telecom or internet. I mean, it's the classic abuse of authority case scenario.
Yeah, so there are legitimate reasons for having this power in place in theory, in the sense that, you could have a cybersecurity threat emerging, like a attack emerging from a particular place, and you want to order the telecommunication companies to cut it off. I don't know that we need this infrastructure for that, because telecommunication service providers are not really in the business of allowing cyber attacks to continue. So usually they will do this on their own if notified of it. But even in the standard use case here, it should be clear that people are the people that could be cut off here could be impacted significantly, even if legitimately cut off. So this could be a situation where my laptop or someone's laptop or phone is compromised and is being used by somebody else to conduct a cyber attack, and then I'm cut off from the network. I don't even know what's happening or why I'm cut off. There's no requirements in this bill for someone to come to me and explain to me what I need to do to get back on the network. So there's concerns even at that level, and an absence of the framework that you're talking about. And then, of course, as you mentioned, as we know, in moments of political crisis, there is a very powerful impulse sometimes in governments to misuse these types of open-ended powers in ways that are politically motivated. And we have had issues in other jurisdictions where the government has labeled what are essentially legitimate political activities, like sending, form email submissions to a regulator, as cyber attacks. So it's not like this hasn't happened before. So it is something that should be concerning and would benefit from additional safeguards.
Matt, is there anything you want to add on this potential to use this bill to have certain people removed from having internet access? What are your concerns?
I think Tamir summarized it well. I think there's what are called botnets, which are compromised devices that you and I might own. We don't realize they're compromised, but they are being used by hackers as part of attacks. And there is a risk under the current form of the bill that we could find ourselves cut off without explanation and without immediate address there. And also building on the point about the risk of misuse of internet disconnection. There's other countries in the world where it's quite common to shut down portions of the internet during elections, during school exam periods. I don't believe this bill is intended to be used that way, but there's a risk of encouraging that kind of future use.
Yeah, and I certainly recall, I mean, during the pandemic, there was a lot of desire to shut down speech that certain people disagreed with. And we didn't think that we would live in a government that censored us, but I think we learned during that era that we actually, in fact, do have a risk of that. We've got to go to commercial break now, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a new piece of federal cybersecurity legislation that's currently being debated, Bill C-8. And this legislation gives cabinet and certain cabinet ministers broad and discretionary powers. One of the things about these powers, the power to order telecoms to do certain things, is that a lot of these powers can be used secretly. So we would not even know that the government has ordered a service provider to do a certain thing. For example, one of the powers we've been discussing is the power to disconnect someone from the internet. So Matt, why the secrecy, and what do you think the danger is in giving these broad powers combined with this lack of transparency?
Yeah, so there's a bit of a shell game happening here where the government will say, in a high risk, urgent situation, we might need to order telcos to do something. The people that are trying to hack Canada or launch attacks on us, we can't tell them what we're doing or what we know. It can't be public information. We need to just act quickly and secretly and get the problem fixed. Fair enough in that urgent scenario, in that first 48 hours, maybe first couple of weeks. The problem is the bill doesn't set appropriate secrecy limitations. So there needs to be a time period. The secrecy needs to expire. They need to eventually report to Canadians, here's what happened, here's what we did, here's the fix. Because in the absence of that, you could have a whole, ultimately a censorship regime grow in secret, or surveillance regime rather, in secret without Canadian awareness of what was going on. And that's completely inappropriate and not justified by emergency situations.
Now, Tamir, the Intelligence Commissioner of Canada has actually warned that this bill would authorize warrantless seizure, or could authorize warrantless seizure of private, sensitive information. And he's actually questioned whether this approach could, in fact, violate Canada's Constitution. Can you tell me about how this potential for warrantless searches would work and your view on the constitutionality?
Yeah, so we have serious concerns over this. The part of the bill will give the government the power to demand any information it believes on reasonable grounds is necessary for managing this regime. And when you're dealing with cybersecurity threats, you're often having to look through a lot of real, people's internet traffic to understand what's happening with a particular threat. So you could be putting significant volumes of highly sensitive information in the government's hands here without prior judicial authorization or any judicial oversight at all. And then there are some limits on who the government can share this information with, but among the authorized recipients are intelligence agencies, national or security agencies. And these agencies do have a mandate on cybersecurity for sure, but also additional mandates and additional things that they could do. And there's no limits on what they do with information that they get for one reason, cybersecurity, and no limits on their ability to use it in other contexts like foreign intelligence, et cetera. So we're concerned about the constitutionality of this regime and how it might be applied and the consequences of having it left as is.
No, Matt, another concern that has been raised about this bill is that it could actually empower the government to order telecommunications companies to weaken their encryption standards. Maybe you can tell me about that part of the bill and why the government would want that.
Yeah, so under C-8, the government could order telcos to install devices that the government selects into their telecom infrastructure. Government could argue, well, we're going to install devices that make protections even stronger. Unlikely, I think. I don't really see that there is a strong rationale for this power. And our concern is that would enable the kind of men-in-the-middle attacks on privacy, where the government would actually be able to collect intelligence, both potentially about attacks on our infrastructure, but I think more concerningly about the private data of Canadians.
Now, Matt, a lot of these concerns, what we're discussing here today, were actually concerns about the predecessor bill, Bill C-26. There's a lot of the same stuff is in this legislation. And civil liberties advocates asked for changes before, but it doesn't seem like they were made. What do you think is going on? Is the government just ignoring these concerns?
Yes. The most generous interpretation you could make of what the government has done is that they want maximum freedom of movement. They believe that they need to be able to make a lot of urgent, on-the-spot decisions around how best to protect our cybersecurity. That's the most generous interpretation. I think you could also say the government is leaving the door open to install surveillance devices and would like to have that power and potentially use that power, unfortunately.
Well, that's two very different interpretations of what this act could be used for, one malevolent and one benevolent. And, I just, from my own perspective, I have a lot of skepticism that we can trust the government to always use a tool in a good way when they have the ability to use it in a malevolent way. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing a new federal cybersecurity bill, Bill C-8, and some of the concerns that this bill might lead to increased state surveillance and violate privacy rights. Now, Tamir, there's this classic argument that people will raise when we talk about the balance between privacy and safety. You sometimes hear this argument, well, if you have nothing to hide, you have nothing to fear. How do you respond to that kind of fallacy?
Yeah, so I understand the impetus, but I think the challenge when you're dealing with highly sensitive personal information like this is that even if you think you have nothing to hide, someone else who is in a position of power might feel differently. And we know that political winds shift all the time, and perspectives that are not controversial today could result in serious consequences for people tomorrow. I'll take the paradigmatic historical example which is the McCarthy era in the United States, where for about 15 to 20 years, we saw witch hunts for anyone who had voiced certain political opinions. People were ostracized, fired, put under intense scrutiny, prosecuted based solely on their political views. And there was even a law passed to deport people who were deemed subversive. So it's typically viewed as a very dark era in the United States history, but sadly, I don't think it would strain anyone's imagination to come up with some modern day analogs. And that's why, we should be cautious and vigilant with our personal information, especially with information of this level of sensitivity.
Matt, what do you think? What do you think when you hear this argument? I have nothing to hide. So if the government looks through my, internet logs, if they get access to my computer, enjoy. I'm not hiding anything, so I have nothing to be afraid of. What do you say to those people?
Well, I guess you're maybe not doing a lot of activism or a lot of engagement with controversial issues in society if you really feel that you have absolutely nothing that anyone's going to try to use against you. But I think we need to look at the world around us, and we look at changes around speech in Europe. We look around changes around speech in the US, where we're in a shifting world. There's a lot of attacks on speech from different angles going on. And I think we've been insulated from some of this in Canada to date, but we simply can't assume that the status quo of what is acceptable non-penalized speech in Canada will be the same in the future, and need to do our best to create both strong safeguards around speech and strong safeguards around privacy.
So, Matt, look, I think all of us agree that cybersecurity is, of course, important. We want to keep our networks secure. We want to keep our devices secure. Do you think that there are changes that could be made to this bill that would satisfy you?
Yeah, potentially, although the course we took last time, I don't think we got there at all. And so I worry about where this one is going to end up. I think it's good seeing the opposition parties say that they're going to give this a deeper look and potentially force some changes this time. We need to get a real protection for encryption into this bill, not just of nominal protection, but making sure the private messaging cannot be compromised. Arbitrary disconnection, like we talked about, needs to be out. No permanent secret orders. And fundamentally, the minister or the government alone should not be determining the reasonableness of their decisions here. So we need a secondary review where a judge will look at what the government does and say, okay, this was in keeping with the purpose of the act or it wasn't, whereas currently the government just gets to sort of decide for themselves.
Tamir, what do you think? Do you think that there could be substantive changes made to this bill that would achieve a better balance of privacy and security?
Yes, I think so, although I share Matt's concerns that we'll actually get there, given how this went last time. In addition, though, to the list that Matt provided, we would be looking for explicit limitations on using this information obtained through this for any other purpose other than what's in this regime. And then also, we would want people impacted by these orders to be notified, because that's not in the bill at all. So you wouldn't even be known if you're being cut off from this bill. I think that's a big flaw. And then, of course, a lot more judicial scrutiny of all elements of this.
Yeah, it's an interesting thing that the government's trying to do here. I think more Canadians need to be paying attention to it. In fact, we at the Canadian Constitution Foundation actually have a portal on our website, the ccf.ca, where you can write a letter to your member of parliament and ask for some of these changes to be made to C-8. And I know that the CCLA and OpenMedia are doing similar campaigns, encouraging people to write in. So Matt, Tamir, thank you both so much for coming on today and telling us all about this legislation.
Always a pleasure.
Thank you.
We've heard today about a new piece of legislation that tries to balance Canadians' privacy rights with the need to keep Canada secure against cyber threats. Did this legislation get the balance wrong and create the potential for widespread surveillance on Canadians' activities online? How do we push back? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.